session on evolution and progress in trademark law, a component of the second VIPS IPR National Virtual Workshop. We would like to extend our greetings to the guest speaker for this session, Professor Ashlyn J. Lembry, Director at the Intellectual Property and Transactional Clinic, University of New Hampshire, Franklin Pierce School of Law. We welcome you, ma'am. I would also like to welcome our dignitaries, Professor Dr. Rashmi Salpekar, Dean, VSLLS VIPS, the faculty, and the participants to the session. The Center for Intellectual Property Rights, VSLLS VIPS, is organizing this two-day national virtual workshop in the memory of Professor Dr. Neeru Nakra, under whose aegis the center was established in the year 2020. The purpose of this workshop is to further the objective of the center to develop the intellectual leadership and capabilities in the field of intellectual property rights and to examine and analyze the emerging trends in the field of trademark law in the present context. Before going forward with the workshop, a few rules to be kept in mind for the participants. Firstly, the participants can post their questions in the chat box, which will be addressed at the discourse of the speaker. Secondly, attendance for all technical sessions is compulsory for participants to be eligible for an e-certificate. The attendance shall be tailed from the list of participants during the meeting and feedback form to check the eligibility. And lastly, links for the feedback form will be circulated at the end of the session and submission of the same is compulsory. Please note, there are separate links for participants of VIPS and outside VIPS. For the first technical session of our workshop, we have with us Professor Ashlyn J. Lembry from the University of New Hampshire. Ma'am completed her BA in Economics and Political Science from the University of Vermont and JD and MIP from the University of New Hampshire, Franklin Pierce School of Law, where she now teaches law. She practiced intellectual property law, general business law, and litigation at New Hampshire firms prior to joining the University of School of Law. Ma'am holds experience of 25 years and teaches a variety of subjects, including US trademark and copyright registration practice, international trademark registration, trade secrets, trademarks and deceptive practices, and online brand management at the University of New Hampshire. In addition, she also represents clients in trademark disputes at the Trademark Trial and Appeal Board within the US Patent and Trademark Office. She is a member and former chair of the Intellectual Property section of the New Hampshire Bar Association, a member of the International Trademark Association, and has a variety of notable publications and presentations to her name. It is a delight to have you here with us, ma'am. We now invite you to kindly begin with your session. The floor is all yours.
Thank you. Thank you very much. What a lovely introduction. I appreciate that. Welcome to you all, and thank you for allowing me to join you on your first session of your conference. Now, give me a moment to make sure I can share my screen correctly as we begin our presentation. Let's see, can everyone see my screen and hear me fine?
Yes, absolutely. Yeah. It is clear.
Great. Thank you. Thank you. All right. So to get started, as you just learned, this is a technical session 1 on the evolution and progress in trademark law, a comparative view. And I'll let you know a little bit about me. I know you just heard introduction, but just to give you a feel for it, I am currently, and have been for 16 years, the director of the Intellectual Property and Transaction Clinic at our law school, UNH Franklin Pierce School of Law. In that clinic, students work on live client matters, and I supervise them because I'm a licensed attorney, and they work under my supervision. The students right now are able to take advantage of a program at the US Patent and Trademark Office where they can enter their appearances on cases. So, so I have several students now, including if you're non-US students. That was a change a few years back, but non-US students can now enter their appearance on cases, and they have a special limited practice number. And so we do a lot of trademark work. They're in the clinic working pro bono for clients who can't afford fee-based counsel. So in addition to running sort of that live clinic with students where I work, actually, that's like the biggest thing I do, working directly with students. I teach other courses. You heard a list of them, but as you probably heard, a lot of it involves trademarks and copyrights. So that's the teaching aspect. I am a practitioner outside the law school, which is a really nice perspective because I get to see clients who can afford more, and it helps me stay completely up to date in the field on what's going on for like clients of all sizes, small as well as large. So let's start with trademarks. I was told we'd have it's sort of a mixed level of experience. So we're going to start back with a cheerleading session, if you will, on trademarks. Trademarks basically are the driver of commerce. And the word brand is kind of synonymous with trademark. And it's been the driver since ancient times of commerce. And branding, for a historical perspective, literally means to burn, and people would burn brands on their cattle to show that they are theirs. So back as early as 2000 BC, Egyptians were branding their livestock, and they were recording that activity in the hieroglyphs in the pyramids. Also like even coins had branding. They were minted in 560 BC. Gold coins were minted with insignia stamped on them. And the purpose, this is important, the purpose is to indicate authenticity and quality of that coin, that it is valid currency to use in commerce. Sorry, I'm managing two screens to keep my slides visible. In 300 BC, Roman merchants used symbols to specify the manufacturer or the seller of the product, such as pottery. And these were used to be, this was a time when pottery was starting to be exported by the Romans, and you could trace back that source to the creator and maybe buy a new set of pottery if you liked it. I actually saw this in person, and of course, because I'm a trademark geek, I had to observe it. So I went to Italy and went into the catacombs that were around 300 AD in age, some of the older ones, and actually saw the vault covers had brands on them. And all I could think, of course, as the trademark geek I am, that those are trademarks that were used even in burial vault covers way back then. And then moving up to the medieval ages, swords and armor would bear marks of their manufacturers. And this not only allowed that concept of authenticity to be tracked and the origin of the goods, but also if there was a defect, you could go back to the manufacturer. Beer was another thing that in about this time period that experienced some branding. So that was used in abbeys to mark the beer for a source of quality. And so now we're up to trademarks of today. As I mentioned, also brands. Remember that branding of cattle burning in. So this alphabet ABCs of brands was created actually by some company online to advertise that they could make your brand for you. Now, you know, you can be just like Facebook or Kellogg's cereal or Pinterest or McDonald's. And so this just hopefully you can take a glance at this and realize that the power that these brands have, and that you yourself can recognize them and immediately think of whatever that source is, and that would that's to demonstrate to you what the purpose of that trademark is, to immediately make you think of that company. So in today, another thing about today's brands is that different from those earlier brands I showed you from history, is that we have both registration and use of trademarks. Before, there was no registration process and they were just put into use, and through time consumers would begin to understand that that mark on that armor or that mark on that pottery or that name for that beer meant it came from a certain source. But in today's world, we have a registration system where the brand owners can make an official declaration that that is their brand. So what all can we use as a brand? It's actually kind of an interesting question. It's not just the words, it's not just the designs that we've seen, but it can take on any sort of device depending on country laws. This law is from the US, and it allows any word, name, symbol, or device, as long as whatever that device is can be used to identify and distinguish that producer's goods from someone else. We call that in the industry likelihood of confusion. So it's supposed to prevent likelihood of confusion, as well as to be distinctive enough to not be descriptive, say, of what your products are, something that is in its nature, something that can be a trademark. There's also a service mark. This is not limited to goods. It can be used for services, and all jurisdictions basically recognize some version of these marks. Some vary. Some recognize holograms, some don't. Some recognize trade dress, some don't. Some recognize sounds and smells and colors, some don't. So that adds to some change. Most jurisdictions also recognize what are called certification marks and collective membership marks. Certification marks, there's an example here, Underwriters Laboratory. That is what's used on your power cords to say, oh, this has been inspected by a nonprofit organization, Underwriters Laboratories, to say it meets certain criteria and it's safe to use. Collective membership marks are those where a group of private individuals collectively own a single mark. It's like a giant co-ownership, think of an association kind of thing. So those are two other types of registrations. And then another type is called geographic indications. There are different versions of these, which I wasn't intending to get deep into this, but they're often called appellations of origin, if you've heard of that phrase before. But a geographic indication is basically, as its name implies, it's a location. It might be Champagne, like the Champagne region, or it might be Parma region of Italy. And you can register in some jurisdictions. You can register that Parma name or Parmigiano Reggiano with there's a system for registering the mark in your home country and for extending registration into other countries, which is under the Lisbon Agreement, which is a multilateral treaty of about 28 countries. The United States isn't in it. So it allows you to protect your geographic indication exclusively to you and those in your club that also meet the criteria. So I saw a hand raised. Do you want me to take questions during the presentation? I don't know what happened to the hand raised, by the way. You'll have to speak up because I'm doing presentation mode.
Ma'am, we can take the questions after the session if you want.
Okay, sure. Yeah, that might be easier only because it's hard for me to see and get them back. Okay, so let's look at some examples of different trademarks. So yeah, so save up those questions. Here are a few of your kind of classic trademarks that involve words and design elements. You've seen a lot of these before. These, I just want to point out, are design only marks. I point this out because on an international scale, these can be particularly helpful where language is an issue. A lot of international filing will, as you'll see later, there's a lot of cross-filing between, for example, China and the United States. The difference in characters and difference in languages creates, I think, more of a need to think about these, maybe a logo only or design only to meet the needs of international recognition of a mark. These are what we call like non-traditional marks examples. I want to point out a few because they're kind of unusual. There are registrations for like the shape of a car. Many car manufacturers now register parts of the shapes of their cars, like the grille on the front, or maybe the overall, bubble shape. There is a pretty old registered trademark for the shape of a Hershey's Kiss. That's a product configuration case. All of these are. A Weber grill has a certain shape that's registered. And those three are product configuration. And then we've got this one, the Taco Cabana case. It's actually, there's a US Supreme Court case about the interior decor of a restaurant, and it was actually held to be protectable as trade dress when another restaurant basically copied it almost exactly. So it had the same look and feel. Goldfish crackers shaped like fish is a registered trademark also for product configuration. UPS, the global delivery service, owns a registration for brown, the shade of brown as applied to their trucks and their uniforms. There's a type of building insulation that's pink, and it is registered to have exclusive rights, so no one else can have pink building insulation. You may be familiar, perhaps, with the well-known case involving Christian Louboutin shoes. They have a registration, and they worked hard to, actually was at the International Trademark Association meeting 2 weeks ago, and I got to hear their in-house counsel talk about how they protected the red sole of the shoe, and it was quite an endeavor, in some cases taking over a decade in a given jurisdiction. And then the Coke bottle. Anyway, so you can register weird and different things, and that's fun to talk about. But moving on, so we have use rights and registration rights. So just as I mentioned, just using a mark can create limited rights, but registration is really empowering. So for example, if we had 2 users in the United States, and they are in different geographical areas, once they expand their geographic scope to come in geographical conflict, the first one to hit that area wins, because the rule is who's got priority wins. But this is a bad system for either brand owner, right? Because they need certainty. Like if they're going to put all this money into developing a brand, they want to know they can expand. So registered trademarks. Registered trademarks have a ton of benefits, just a ton. They can be cited against new applications. So you can, in some jurisdictions, the EU doesn't practice what's called relative examination, but they can be cited against other jurisdictions. So against new applications, sorry. So they stop people from entering and getting registration. So just being on the register does that. Being unregistered doesn't do that. They can use this R circle symbol, just like scaring people away. They can, because they're on the register, when someone runs a trademark search, they'll find that other mark. It could deter an entrant to the market before they even file. Importantly, and the next slide kind of describes how this works, it will create constructive nationwide use. So within the country you're filing in, just that country, it's construed to be all over the jurisdiction, and it creates a priority. Remember how I said the one with priority kind of wins, more or less. So it creates, the priority is presumed as of the date you file that application, even if you don't put it into actual use until later. So here's an example involving the United States, because registrations are on a jurisdiction basis, where, and under US laws, if you have an unregistered senior user, so that's the blue circle. The blue circle user didn't get a registration, but it's been using a mark for a while. It's in the northwest area of the United States, so it's got recognition of consumers there. But later on, along comes red triangle. Red triangle is later comer, so should lose, but it doesn't really lose. It files for registration, and even if it's only using in the southeast area of the United States, it has presumed constructive use over everywhere except the area where blue circle is. So the brand owner with the registration in this scenario fares better, despite the rule that of giving rights of use to the first comer. Continuing on with the many benefits of registered trademarks, you get exclusive right to use. There are a lot of limitations on that, but generally you're considered to have exclusive right to use in the territory. And it makes it easier to sue for trademark infringement. There's also a thing called dilution. If you have a well-known mark, which we call famous mark in the United States, you can sue for things called tarnishment and blurring. You could get, as remedies, you could request that an injunction to stop someone else from using, or money. Also, you can use that registration and register it with the customs office, and they might prevent imports coming in that are infringing. Importantly, you need to have a registration to extend protection into another country, and using some treaties we're going to talk about shortly. Also, longer lasting registrations. So if you get a registration older than 5 years, these benefits start to kick in. They preclude some challenges to trademark rights, and they serve, just the longer you have a registration, the stronger it seems the duration of use that your brand is, which can help you in some of these lawsuits. So all of which I could get into in more detail, but I don't think we'll have time. Other benefits on registered trademarks is that a lot of brands are not sure about whether they can adopt a mark. They may have run a trademark search and somebody is close to it, but they don't know if it'll be a problem. And they could file the trademark application and see how the IP office, the trademark office of whatever territory it's in, whether it gets cleared. And then the examination process also includes usually pre-registration opposition period, sometimes it's post, opposition period where a third party can come and oppose. So there are two tests there, one from the Intellectual Property Office and the other one from opening up your mark to someone challenging it after it's published. So the other thing about registered trademarks that's really valuable and isn't in any statute really is just using that piece of paper in your work in commerce. It gives you a claim of validity if you have a domain name dispute and you file, a UDRIP action, UDRP. If you're doing a takedown complaint, that's like you see an infringing mark on somebody's website and you ask the website to take it down. Like if it's Google, you can do a Google or YouTube takedown complaint. If you're buying a domain name in one of the new generic top-level domains, you get priority registration for that, and it's called a sunrise period. You are able to enroll in certain programs with Amazon and eBay to get them watching out for infringers. And then a lot of businesses use Amazon brand registry for their Amazon site, and they pretty much need a registration. However, so registration is super great, but the problem is registrations are limited to the jurisdiction of the registration. This is called the territoriality principle. So what this means basically is that if you register in the United States and it doesn't mean a hill of anything for Europe or India. So you've got to register in each of those countries, which is a lot harder than you would think. So how do you do that? Well, there are a few different ways, but there is online filing available in the if I had a client in the United States, I would probably start with a US application and then make a decision on whether to use what's called the Madrid Protocol to file in the US Patent and Trademark Office and say extend protection into India, or if I just hire counsel in India and do a direct filing there. So those are some things we'll briefly cover. So let's review where we are now. Let's see. So trademarks can be, words or logos, or sometimes product configurations or product packaging or colors or sounds or smells. Trademarks are really helpful with commerce because consumers can find the source. They can repeat buy, they can look for a certain quality, they can trace it, use the brand to trace back to the source if there's a defect for something where it's important. And it's important that consumers not be confused as to when they see two competitors' brands. So that's kind of some of the benefits of trademarks. And then what happens when there's a conflict? So first to use has some senior rights, and this would be in the United States, which is a use-based country. However, registration can create priority that's akin to having use. So it can be a substitute there. So that's why I say it's sort of first to use, because registration can trump that. Or change the analysis on those dates. Also, registration can claim territory not yet in use, only in that jurisdiction, but it can do that. And then you can get a registration from the USPTO or whatever the IP office is. And there are many benefits to having a registration, which I listed. But the downside is they're limited to a jurisdiction. I'm showing you here, I actually just did a search on the USPTO website for the most recent registered marks. And this is literally the most recent registered mark that had a design element, because I thought it was interesting to have design, but the vast majority of US registrations are just words. So this one is for, I think it's pet blankets. So that's what it looks like. All right, let's talk about registration systems. And I'm not just, okay, I'll look at that later. So there are national registration systems as well as treaty-based registration systems. And there are tools to help us with filing in most all jurisdictions of interest. Let's see. Oh, okay. There are a lot of trademarks. So I'll go through the chat unless someone wants to monitor the chat and interrupt me. But I see there's a lot of good questions. So let me just talk about this. So go through the slides. So types of filing, you can do a national filing, which is direct to the IP office of the country or of the region, or you can use convention priority. Here I have an image of sort of the cover of the 1883 Paris Convention document for the protection of industrial property, which we can talk about in a bit. And then there's the Madrid system, which allows you to get an international registration, which, by the way, is not as it's not in and out of itself something that gives you rights, but you can get an international registration from the World Intellectual Property Organization. There are lots of rules with that, which we can talk about, and it allows you to sort of send applications to other countries. So that is super convenient. You pay a little bit of a fee for that. Let's talk about the Paris Convention first. It's WIPO administers it. It was 1883. By the way, India joined in 1998. The number of countries was, I don't know, just a handful in 1883, and it is now 178 contracting parties of, it depends on how you count it, about 193 countries in the world. Two main points about the Paris Convention I'd like to point out. One is national treatment. And so each contracting state has to grant the same protection to nationals of other contracting states that it grants to its own nationals. So it's sort of a most favor, treat everyone the same issue with IP. And then the other thing that's really important is called convention priority. So basically, if you file in your home country, and then you file in, say, let's say you file in India, and then you file in the United States within 6 months of your application in India, you can claim priority. You have to do a few extra steps, but you can, so the USPTO knows, but you can claim a priority date based on your India application date. So that convention priority is used actually as part of the Madrid system as well. So the Madrid system, so actually I took this graphic from WIPO, which manages the Madrid system. This is from the year 2016 and celebrated 125 years of the Madrid system. So that's been around for a while. So you make, as it shows, you make one application after you do your home application, let's say in India. Then in India, if, you should be able to do this. In the India IP office, you would make an application extending, getting an international registration with WIPO, and then you pay your fees in your currency in India. So it'll be, you have to convert it probably from Swiss francs, or your IP office will do it, but you can pay in whatever method you normally pay in India. And then you get one filing language. So when you get notifications, they'll come into the language you've selected, as long as you choose one of the ones that WIPO uses. So it could be English, Spanish, French, I believe now German, and Italian. So then when you get registration, let's say you file in 10 countries off of that international registration. Those are called, by the way, extensions of protection. When you file in those 10 countries, you can mostly control those registrations in the 10 countries in terms of post-registration maintenance or changing the owner of record if you sell your business, or changing the attorney of record. You can do that all with that one WIPO registration called the international registration. Back in 2016, there were only 97 members. Now it's on a slide. I think it's 100 and it's over 100. It's like 110-ish. So, and it's in the WIPO covers statistics of how much trade is involved. So this shows the growth of membership with the Madrid Protocol, starting with 9 members in 1891. And then, well, to today, it's over 100. And so this changes. The slide on the right side also shows how things have developed. What was really interesting is the beginning of electronic filing. The United States really implemented it in the year 2003. I was actually around for that and remember it. And they had to rush out an electronic filing form so we could meet the Madrid system requirements, but it was there. We could do it at the US Patent and Trademark Office. And India is as a member. So it's still, so it's just growing, basically. It's just a better, it can be a better system. I don't always recommend to my clients that they use Madrid Protocol. You have a base fee of 653 Swiss francs. And then each country usually charges what's called individual fees. And those usually are more than you would pay if you did a direct filing in their country. But it would save you, if you have more than like 3 application countries you want to extend to, 3, 4, 5, depending on whether you're doing Europe or not, because Europe has its own trademark registration and it's expensive. It's over $1,000. But depending on what trademarks, what jurisdictions you're filing in, it can be very cost effective because you don't need to hire local counsel. And if you don't get a refusal, you may never have to hire local counsel. So evolution in progress is great. And what it has done is it's created this infrastructure with the Paris Convention of establishing sort of some baseline, fair treatment and priorities so you can get into a foreign country and gives you time to take care of the filings. And the fact that you can basically e-file, just get your application filed in over 100 countries at once if you wanted to do that. That would be very expensive. It's just like a highway. It's just a road that enables you to just have a filing boom. So that's exactly what happened. So taking these from actually recently, just November 8th, WIPO, every year WIPO publishes World Intellectual Property Indicators. And these statistics were taken from the report issued just a couple of weeks ago. So there's been a consistent every year-on-year growth over the last 11 years in trademark applications, exceeding the expectations. There was even just a boom in 2020 when there was a pandemic, 13.7% growth worldwide. The growth in India alone in 2020 was 15.4%. Largely, this was pharmaceutical driven. And these counts are based on the number of classes per application, not the number of applications. So when you file an application, you could have anywhere up to 45 goods and services classes, 45 goods and services classes. And so the count is based on those classes. So there's 34 goods ranging from class 1 for paint, class 3 for face cream, class 10 for medical equipment, class 9 for computer equipment, et cetera, et cetera. So those are the classes, and that's how these counts are done. 17.2 million classes were filed worldwide in 2020. That is just really large. As of 2020, in terms of so the first statistics are about applications, but then if we just look at how many trademarks are out there per if you count by registration certificates counted by class, over 64 million. And so that's up 11.2% from the prior year. Almost half of those registrations are in China. The number 2 spot is the United States, 2.6 million. So 30 million, under 3 million. And then the next up is 2.4 million in India. In the year 2020, India's office overtook Japan to become the 5th largest office for trademark filing activity. So here's an interesting trend that's happening with US and China, actually. So if we're looking at the USPTO, comparing April of last year with April of this year, if you look at the red bar, there's a massive growth relative to overall filings of China-based applicants, whereas other country applicants are staying pretty static, right? So that is an interesting trend. So it's something like, why is that happening, right? So let's think about it. The US and China are actually the top 2 filing offices by volume, but the US is far below China in terms of volume, but we're still the second highest volume. So there are 9.3 million applications by class count in China in 2020. US is less than 1 million. So why are Chinese applicants filing in the US? And by the way, there's a lot of US filers into China as well. Here's my guess. If they're high volume offices, then there's a greater risk for refusal. If you kind of sit back and wait until you move into that jurisdiction to file, someone might have taken your spot, because both China and the United States practice relative examination, meaning they will refuse your mark if there's a likelihood of confusion with a prior filed mark that's still alive. So, so what people are doing is trying to get in early, basically, because they don't want to be refused later. And it's pretty low cost to get an application in compared to trying to expunge or cancel some prior registration because they weren't using it. So where does all this lead? All these trends of higher filing and cross applications, trademark depletion, increase cancellation activity, focus in countries such as India, all of that. Yes, I think it will lead to that. So there's some trends in terms of trademark depletion. I don't know that there's really trademark depletion, but the idea is it causes fear. So people are wanting to file to get that space on the register, and especially for the popular countries. India is now number 5 for most popular. Also, there's this concept, some countries are registration right countries, some require use, but you can use, you can manipulate the system. You file in a registration right country where you don't have to be using in that country, and extend to get to other countries. So for example, I'm pretty sure no proof of use is required in India. So that's, I think you file in India, correct me if I'm wrong, those of you who are practitioners there, you can file in India and then extend protection into the United States. And I do know that when you don't have to use in the United States, you do have to have a bona fide intent to use. And then now under the the United States just passed the Trademark Modernization Act. It goes into effect next month, like in a few weeks, couple weeks really. And under that, you really need to put your mark in use in 3 years in the United States. But you kind of get a pass on proving use pre-registration in the US. So because there are more blocked applications likely to happen, there's going to be more cancellation actions to get rid of deadwood registrations. So IP office examination procedures, there are going to be, there are already rapid expungement proceedings exist in multiple jurisdictions, and with the Trademark Modernization Act in the US, it's coming online in next month, where you can, it's ex parte in nature. You don't even notify the other party, or the office can initiate it on their own. Those are new ways the US has adopted to get rid of deadwood, registrations for people that aren't using a mark. Filing fees have increased in the United States pretty significantly, especially for maintenance of post-registration maintenance, but for a lot of things. China reacted in 2019 to add a pretty high-powered law that says if you file a trademark application in bad faith, you can be penalized with monetary penalties. And so I listened to a couple sessions at INTA, and there are several cases on that, with significant fines involved, or damages, I should say. So China is actually instituting methods to prevent people from trademark squatting, because that's basically what this fear of trademark depletion is leading to, is trademark squatting. The US also added a requirement in 2018, joining a long list of countries, requiring any foreign filers or parties before the Trademark Trial and Appeal Board to hire US-based counsel licensed in the United States. As a footnote, at our law school, we get quite a few LLM students, master's students who are practitioners in their home countries, but they come to the US to get an LLM so they can sit and take the New York bar exam, or Massachusetts or California. They take a state bar exam, and then can go back to their home countries, and they can better help their local clients in their home countries without hiring US counsel. Another reaction of IP office examination rules is to change requirements to show use of a mark in the country. So Mexico added one. The US already required it, but they doubled up on the requirements. They added fees. They're doing an audit procedure. It's just hard to show use properly. It's actually too much, in my opinion. Canada went the other way, though. They removed their use requirement as part of a law change to join the Madrid Protocol. So I feel like maybe I shouldn't get into, well, I will briefly. So there's another reaction that IP offices can take, which is to just really hammer hard on all the refusal grounds so that less applications get through. One way they can do that is by taking a more expansive view of the descriptive. It can't be merely descriptive requirement. So, for example, the mark kangaroo kindergarten for child care education program, where the word kindergarten is generic and just means, at least in the United States, it means like a preschool for little kids, place where kids go to have early education. If you had the mark kangaroo kindergarten, you might have protection, a registered mark for the whole thing, but you only get exclusive rights over the kangaroo portion because it's suggestive or fanciful as to, which is a strong mark, as to the services of this child education program. But the word kindergarten can be found in a dictionary and should be free for everyone to use. So someone else can have my first kindergarten, or, you know, super duper kindergarten, Ashland's kindergarten. So so I found that the PTO, anyway, that's my personal experience, is definitely looking harder at applications on things like this, among others. So as I cycle back into trends in the evolution and, you know, predictions on trademark law, I just wanted to point out that treaties will feed country law, and country law will feed treaties. Oopsies, here we go. So here are a few treaties. The Paris Convention in Madrid, we talked about Lisbon Agreement, which is for geographic indicators. There's the TRIPS agreement, trade-related aspects of intellectual property. TRIPS will make it, there's a provision now in US law that's refusal if you have wine or spirit that uses a geographic indication that isn't in the US. That's not exactly right, but it's close enough. So here are some examples of how territorial laws are a little bit unified. If you go to the INTA country guides or the Madrid member profiles or whatever resource you might use to look at individual country laws, which I do on the regularly, I go and look up country laws because I need to, either to teach or for a case. And so I compare their laws against each other, and there are a lot of similarities that are harmonized because of treaties. This is just a handful, but here's some examples of how they're harmonized. Most countries you'll see will not allow registration of flags, coats of arms, or other insignia of some government, whether foreign or domestic. You may see that if a mark lacks inherent distinctiveness, it can rely on acquired distinctiveness. As part of the Madrid Protocol, like Canada had to change its registration renewal cycle from 15 years to 10 years to meet their, so everybody's in line. There's Paris Convention requires protection of well-known marks. The US doesn't do a great job of that, but they're supposed to be harmonized there. We talked about TRIPS. And then as part of treaties, filers can pick 3 or 5 years after a mark is registered or applied for to put the mark in use in the territory. And then electronic filing. Treaties have driven a lot of, even in the US, to a lot of countries to really make a better move towards better electronic filing or electronic filing at all. Electronic filing, this is just a screenshot of a portion of an application at the USPTO. But electronic filing is great. Like it's been a massive change in trademark law, and it's made it's so much more efficient to get these filings made. So conclusions, registration is important. Global commerce and different country laws are driving application procedures, and treaties are driving different country laws, and there's massive registration expansion that's going to lead to further changes. So I'm ready for questions, and I think there are a lot. So
yes, thank you so much for your address. And yes, there are many questions in the chat box which are waiting for your response. So would you like to go directly on questions, or would you like to take 1 minute just to take rest for your throat?
I'm fine, I think. Is it sound that bad?
No. I'm just, because the questions are quite elaborative in nature. They are quite interesting and very elaborative as well. So please, once again, floor to yourself.
Okay, great.
Shall we read out? Shall we read out questions for you?
Sure. I'm reading them now. Actually, so the first question is from Pravani, and the concern is the cost to file. The best way to save cost, a few things. Madrid Protocol can be cheaper if you are going to expand enough to hit that magic number where paying for Madrid makes sense. You can save on hiring local counsel in the different countries. I teach international trademark registration. One of the students, so I make them register for membership at the International Trademark Association, which is at inta.org. It's $25 for students. And that was their reading material. INTA has practice guides. And one of the assignments I gave my students was to check what countries require you to hire an in-country attorney, because there's a way to search that on their country by country guides, and which do not. And so if you were, say, acting as in-house counsel for a startup and you're just trying to save money, I would find the list of countries you want to go into. I would probably include China, the popular countries like China, and the US is a different animal, I will say. But anyway, and see where you could file directly and maybe save some money. Trademark applications are not that different country to country. It's wonderful to have the advice of local counsel, but if you really are in a budget and you can't afford, a lot of local counsel will charge $450 to $650 US to file if they're do it in volume kind of thing. But if you really need to save that, because it does add up, then you can look and see where you can file direct on your own if Madrid Protocol isn't the cheapest way. And the other thing is to just be strategic. Sometimes a stage process is helpful to keep your costs down. Go into the countries of highest core value and those where you have the biggest risk first. Obviously it's better and safer to file sooner, but yeah. And another thing is, so you don't waste your money and get a refusal, is run a trademark search. The global, if you Google global brand database, it's roughly a good worldwide search. So I hope that answers your question, Pravani. Sakshi, can you remember the? Okay. Sakshi Jain, hopefully I pronounced your name correctly, wants me to elaborate more on the benefits of long-lasting registrations available in the US particularly. If you're trying to establish, if you have a likelihood of confusion battle, one of the factors, there's a list of 8 or 13 factors, depending on which court you're in. But there are factors to decide whether, which test you're applying. But all the tests include strength of the plaintiff's mark as a factor. The stronger the plaintiff's mark, the more, it favors the plaintiff in winning. And so if you have a registration that's that's been around for a while, that's one factor in showing strength. Usually strength looks at commercial strength, like how many units do you sell, and is your brand featured in articles, and do you spend a lot on advertising? But that is one factor. It's also a factor if you're trying to establish fame of your mark under the thing called dilution. But the other benefit of long-lasting registration is Starting at year 5, you can apply for something called incontestability. You have to have used your mark continuously and exclusively for at least 5 years prior to the date you file. And you cannot currently, at the moment you file, have your mark under trademark challenge. If you get incontestability, it does you nothing for administrative things at the USPTO. But if you go to a court and you're in a court system litigation, incontestability shields you from a bunch of things. There are lots of exceptions, but the best example, I'll just oversimplify here. The best example is if your mark is kind of descriptive, but it got through examination and registration and it wasn't under, they managed to get incontestability in, then if someone, like if you go after someone in court and they counterclaim against you that your mark is descriptive and you never should have had a registration, you can say, whoop, it's incontestable, you lost your chance. The other benefit of registration is at the USPTO. So on the administrative side, it's not tied to that extra filing for incontestability that you have to apply for and pay $200 for. Instead, it just happens after 5 years of registration. Then a Trademark Trial and Appeal Board cancellation action cannot include likelihood of confusion or descriptiveness. So you'd have to go to federal district court for those. So that is the answer to you, Sakshi. Simrat, how could you, hold on. How could you say that the area of trademark is increasing? So I think Simrat is looking at and feel free to chime in, please, but non-traditional marks is expanding. I guess I've seen in my practice an increase in filings. I am also doing it myself. At the USPTO, we don't have many registrations for scent marks, but there are a few, like, color is an increasingly popular item, as is trade dress. For jewelry, I've seen a lot of intricate jewelry. So jewelry is really hard to protect under intellectual property. I will just tell you, it's a challenge. So jewelers will add a little decorative item on the side of every ring or something, and they will try to, or there'll be some distinctive way they always do their trade dress, and those are used more, I think, because infringement is greater. People are going for the look and feel, the infringers. I hope that answers your question. If not, chime in. I'm just going to read Utkarsh's post. No. Okay, so Utkarsh's comment is about the little guy being infringed for the big guy. I do not know whether there's a recognition in India of reverse confusion. We do have a cause of action in the United States called reverse confusion. Under that one, if the large brand owner comes after the small brand owner started using and adopts a confusing mark, then consumers are just, if the two exist, big guy and little guy, consumers will think that the little guy is naughty and was engaged in trademark infringement. If a finding of reverse confusion happens, the monetary damages will include the ability for the small user to fully rebrand. And so that's one possibility. If the injunction to stop the large company doesn't work. I would also say that there's been small businesses have also used the internet to their benefit. It used to be that large companies would send really nasty cease and desist letters to small companies and try to scare them into stopping to use their trademark. I have seen, like in my practice, a total decline on that. The letters are much nicer. My letters are nicer than they used to be, as a matter of fact, because they make it to the internet. And the big company is vilified as is this trademark bully. And that has actually, I've seen it effective with my small clients. So as a result, companies are sending nicer letters like, we see you're infringing, and maybe we could talk about a coexistence agreement where maybe you agree to stay out of my space, or you slightly change your mark or your registration. So I hope that answers the question. I'm now looking at Apoorva's question. So should any policies be focus such? I think I've answered that before, Apoorva, in terms of the small business affording registration. The Madrid Protocol is really, there's no way to actually file truly in multiple countries. What you do under Madrid is you file in your home country. That's your base application or registration. Then you file in your home country a second time for a Madrid application that is communicated to WIPO, which is in Geneva. And then WIPO very quickly issues an international registration. And that's a great way to track everything else, but it doesn't give you rights in countries. In that international registration, you also designate countries off of it, so you may start with India, and there's a dependency rule. You have to make sure your base registration in India stays valid. The dependency exists for 5 years. But anyway, so then your extensions off that international registration, that international application you file lists what countries you want to file in. So all you're doing is using the international registration to pre-populate the applications in the other countries. Pretty much, you can do a little customization, you can, whatever, but that's what you're doing. So that's a pretty good policy. I don't know that we're going to get much better than that. But that's what we have. I'm now looking at Manat's question. Default goods through e-commerce breaching the trademark license agreement. I'm not sure what Manat is asking. I feel like maybe I don't know what the default goods. First I thought, well, maybe you're talking about proving use in commerce and whether e-commerce can qualify. Most countries require that you're selling goods to consumers in their countries, or providing services in the country. But I'm struggling to connect that with breaching the trademark license agreement or other agreements. So if you're, I guess we could get a little into trademark licensing. If you're a licensee on a trademark license agreement, there is often an acknowledgement of the licensor's exclusive rights and the validity of the trademark. So, and generally speaking, although some countries are different, the licensor is the one who, the trademark use inures to the licensor's benefit, not the licensees. But if the licensee is going out and registering a trademarks owned by the licensor in breach of the trademark license agreement, then chances are what's going to happen is you're going to have an opposition from your own licensor and a breach of contract provision action. I'm not sure that was the nature of the question, but if not, just chime in and let me know. So Nietzsche's question, the impact of tariff concessions if given on IP rights in e-commerce. So if given on, I don't know. IP rights in e-commerce. I'm not sure the answer to your question, Nietzsche. Like if we started charging tariff, that would be right now. I'm not sure. I don't know what the tariffs are, but in the United States, there is no. Well, actually, we're changing that. I don't know. I'm prepared to answer that question. Okay. Chaitanya asks, filing in bad faith. So that is a loaded question, Chaitanya. So I could pull up my slides maybe from INTA. In China, the standard, I believe, actually I might circle back to that, but it's basically, they look at factors similar to UDRIP bad faith factors to see if you're squatting. Do you have a warehouse of other trademarks of others? Do you have a large volume of trademarks? Are you not producing the good? Are you not doing any kind of actual production? All you do is own your business entity, only owns trademarks. Do you have suspicious corporate filing where maybe you file in Hong Kong? So there, you look at a bunch of factors, and then if bad faith is found, the result is that the practitioner can be charged who filed. I understand that to be the case in monetary damages, although I didn't hear about any cases where that happened in the INTA annual meeting in the sessions I attended. And but I did hear of significant money damages against squatter filers. So now I'm looking at Utkarsh's question about geographic indicators. And some other may be diluted with so-called local variety, which is either variant, same violence. Okay, so I think that's the last question. Okay, so protected, it couldn't be used. So oh, you're welcome. I think that wines and spirits have a special place in negotiations. When we're talking about treaties, we're talking about diplomatic relations and negotiating power. And wines and spirits are particularly called out and uniquely protected in ways that, like, champagne-like can't even be used. You have to use sparkling wine, basically. You can't use things that even consumers would understand. It's not champagne. It goes beyond what we would normally do in US trademark law. So I would say negotiated agreements. The United States has a bilateral agreement with the EU on a list of wines and spirits that are specifically named, that no one can have those registrations unless it's an applicant who's certified in the home country. So each home country with a geographic indication registration system has either a PDO or an appellation of origin, and they have their own rules about it may not just involve production in the geographic area, but they may have a government authority who does quality control and arranges, controls the method. It goes beyond just being there and using the word. So I would say that local laws and what local law the geographic indicator is registered under puts that geographic indicator in a certain channel, if you will. As for local variety, I would say that I'm not sure of the example you're talking about, but maybe if it's Parmigiano Reggiano and then the local brand of a certain farm, then well, I can tell you, I actually looked it up. Parmigiano Reggiano is a collective membership mark. So I would think it would be by the internal trademark usage guidelines of the collective membership as to whether the local one is violating it or whether it's permitted. So that's my best guess on that answer. But yeah, so, and then I think we have a hand up from Dr. Jane.
Hi, good evening, Miss Ashley. Actually, very nice lecture we had today. But just wanted one clarification on one point. Since India is a common law nation, we follow the procedure for passing off. And if a trademark is not registered, even in that case, if the registrant proves that there is a prior use, there is a provision relating to protection of that trademark. So just wanted to know, is there anything like this under United States jurisdiction as well? Like we do consider even an unregistered trademark under the action for passing off.
So yeah, so I think you're meaning like if you have an unregistered user that's first, then and the registrant comes in.
We do provide, yes, like we do have passing off action in India, where even if the trademark is not registered, even in that case, the protection is given to the unregistered user also. But the consideration is that one need to prove prior use, that for past 3 years or the person was using it, there was prior use of that trademark, then the protection is given. So even if a person is coming up like under the proceedings for registration, even in that case, the protection will be given to the unregistered user under the common law protection. So like this, is there any provision under the United States also relating to passing off?
Yes. So it's not, well, there's a couple of ways there's protection. One is Section 15 of the Lanham Act, which is our Trademark Act, says it's the graphic with the blue circle and the red triangle. So Section 15 basically says that unregistered user can continue using, they're just frozen into their current expansion. In today's day and age, it's usually not a geographic limitation unless it's a juice bar or a personal services salon. You know what I'm saying? Those are more local. But in any event, they would be limited to that area. They do not get the ability to get a registration just by being there, because the USPTO does not search for unregistered marks. So the USPTO doesn't know. That's why we have the statutory provision that says if one of the other parties sue, then it would become an issue. So the conflict would need to become ripe. We also have an older case called Don Donuts, which many of our students are frustrated by a little bit, where there's a, I think it's a Michigan company that was selling donuts under Don Donuts or Donut Mix, and they pulled out, they used to have a plant in New York, in the state of New York. They pulled out, they laid off several workers. This is in the 1950s, I think. But they were the first user and they had a registration, and they sued a donut business in New York, using Don Donuts, and they lost. And the reason was that the likelihood of confusion had not become ripe. The two brands, even though one had registered rights, there had not yet ripened, because these were locally consumed items, that there wasn't enough there for an injunction to lie. Now to go to your question, like if the unregistered user has to do something to get that registration, they could file their application after the other one does, and then oppose or petition to cancel the other one and win. So I don't know if that helps.
Yes, ma'am.
Okay.
It was good. Yes.
Thank you so much, Director Ashlyn, for your wonderful address. And most of our participants, they are students, and some of them, they are legal professionals as well. And there are many faculty members also who have joined your session. So that was really very wonderful and interactive session. You have addressed patiently to all the questions. So we all are extremely grateful to you. So indeed, presentation was good. And after that, very patiently you have handled all the questions. So that is really a cherry on the cake. So once again, thank you so much. And I would like to reiterate on the a bond between our Vivekananda Institute of Professional Studies and the University of New Hampshire Franklin Law School, because we are having a memorandum of understanding, MOU, and thereby our students, they are able to come in your law school, and your university, I'm thankful to your university that they have announced a Vivekananda scholarship as well for the students of law who will join for masters in your university. So thank you so much. And when you are here, so I'm hopeful and in fact very optimistic that very soon my students will come to your country once again with their own questions, and I'm sure that definitely you will satisfy them. So once again, thank you so much. I'm looking for that day when you will come personally to our law school, and that will be really a treat for our students of law. So with these words, thank you so much. Thank you.
You're welcome.
Thank you so much, ma'am.
No, thank you.
For such an insightful and an informative session. And I would also like to thank our Dean, Professor Dr. Ashmi Salpekar, ma'am, for the vote of thanks. With this, I would like to state the concluding remarks. And I would like to thank everybody for joining us today's session. It has been a wonderful experience to hear Professor Ashlyn, ma'am. And the feedback form for all the participants has been shared on the chat box, and all attendees are requested to please fill in the same. With this, thank you for joining this session, and we hope to see you all again tomorrow morning, 9 a.m. for the second day of the workshop with Dr. Sunanda Bharti, Mr. Ranjan Narula, and Professor Dr. Alka Chawla. The link for the session has also been provided on your registered email IDs. We hope that you have a great evening. Thank you and good evening. Thank you so much, ma'am.
Thank you. It was a pleasure. It was nice to meet you.